So up next, a woman who has over 4 decades of experience in social justice and in human rights. She's involved in matters concerning sex and gender and race and class and their intersections. She was also the United Nations Special Rapporteur on violence against women from 2009 to 2015. She's currently a professor at the Human Rights Program at the University of Cape Town in South Africa, and she's here today to talk about her vision for radical solutions to end violence against women and to achieve gender justice. Please welcome Rashida Manjoo. These things happen, people. Nothing wrong, we say in Jamaica. Thank you, Ms. Manjoo. Just wait for your pedestal. Thank you. Thank you, gentlemen. Once again, Rashida Manjoo.
Thank you very much for that, and I'm hoping to see familiar faces in the audience. Distinguished delegates, colleagues and friends, it is an honor for me to participate in this conference and to provide a perspective on international developments in respect of violence against women. Thank you to the organizers, the Global Network on Women's Shelters, the host, the Garden of Hope Foundation, and the sponsors, the Ministry of Health and Welfare. The input by the Director General of the Department of Protective Services on the government's shelter policy reflects the importance of codifying state responsibility to provide accommodation for abused women as reflected in the Domestic Violence Prevention Act. The obligation of the local government to provide short, mid and long-term shelter is a positive example of how state responsibility is incorporated into legislation. The challenge, of course, is the low uptake rate by women of shelter accommodation, which is about 5% on one of the slides, and that's a reflection of how much more work is necessary to address the personal, the institutional, cultural, and societal factors that influence and shape the decisions of women about moving into shelters. As we know, the violations of women's human rights, whether linked to civil, political, economic, social, cultural, or developmental aspects, is a widespread problem globally. Violence against women and girls is acknowledged as one of the most pervasive human rights violations that we face today. The forms, the prevalence, and consequences of violence experienced by women has led to numerous reports which analyze the legal and institutional developments, including on the effectiveness or lack thereof of access to remedies for violations of this human rights violation. Currently, an important conversation is taking place about how to achieve a more effective international response to violence against women. The questions are framed broadly as, should we strengthen the existing legal frameworks? Should we adopt a standalone international treaty focused solely on violence against women? Or should we adopt a new optional protocol to CEDAW with its own monitoring body that is focused solely on violence? Supporters of a new international treaty recognize the urgent need to establish uniformity, specificity, and state accountability through a binding global instrument rather than maintaining the status quo with various inadequate standards and obligations for different regions of the world. It is argued that the vast knowledge that we have developed over decades about practices and lessons learned at the national and regional levels need to be drawn on in the development of an international legally binding treaty. The importance of accountability derives from concerns about the failures of states in their responsibility to act with due diligence in responding to and preventing violations of women's human rights. The principles of dignity, equality, freedom, justice, and peace underpin the Universal Declaration of Human Rights, which is over 70 years old. Article 2 notes that everyone is entitled to all the rights and freedoms set out without distinction of any kind. The right to life, liberty, and security of the person is included in Article 3, and the right not to be subjected to torture or to cruel and inhuman or degrading treatment or punishment in Article 5. If we link Articles 2, 3, and 5, it is clear that these rights apply to all women and girls without distinction, which is crucial for a life free of all forms of violence. There is global recognition that violence against women is a pervasive and widespread human rights violation that exists across the world. It has been labeled as an epidemic by the World Health Organization, and the indicators are that violence against women is the foremost cause of death and disability among women. This is in a World Health Organization report. UN Women has noted that malaria, cancer, traffic accidents, and war combined kill fewer women than violence against women, and this is most often at the hands of people that they know. As I noted in a report to the General Assembly on the subject of gender-related killings of women, the death of a woman is the ultimate act of violence in a continuum of violence that women experience. It is not a new act and is in fact a reflection of the failure in the responses of states to other acts of violence that have been experienced. For more than 4 decades, the global movement to combat violence against women has strived to ensure that the issues relating to women and gender-based violence are discussed within a human rights discourse. However, it was not until the Second World Conference on Women in Copenhagen in 1980 that a resolution was adopted on battered women and violence within the family. As positive a development as this was, violence against women was not characterized as a human rights violation, but rather as a social problem within the ambit of health policies. In 1985, at the World Conference on Women in Nairobi, violence against women emerged as an issue of serious global concern that needed the attention of the international community. Subsequent UN World Conferences, including Beijing, Cairo, and Vienna, have reinforced and expanded on the issue of violence against women as a human rights violation. Unfortunately, the text of the Convention on the Elimination of All Forms of Discrimination, CEDAW, does not explicitly address violence against women. Article 2 of CEDAW refers to the obligation of states to pursue by all appropriate means and without delay a policy of eliminating discrimination against women. But there are no provisions which deal specifically with the issue of violence against women or the state's responsibility to act with due diligence to eliminate all forms of violence. The only article linked to violence is Article 6, which deals with sex trafficking and prostitution. To address this shortcoming, the CEDAW Committee has issued interpretive guidelines in the form of general recommendations 12, 19, 30, and 35 linked to violence against women. Other general recommendations make reference to violence where relevant. General recommendations of a treaty body are not legally binding. These are the interpretations of a treaty body. The optional protocol to CEDAW allows for the submission of individual and collective petitions alleging discrimination. In respect of individual complaints mechanisms, approximately 120 cases have been registered since the optional protocol came into effect in the year 2000, with approximately 50% being admissible. The committee has finalized 14 communications, 1-4, focusing on violence against women. Such decisions have covered sterilization, forced sterilization, domestic violence, rape, sexual harassment, stalking, etc. The low statistics are worrying considering the widespread and pervasive problem that we are facing. In 1993, the General Assembly adopted by consensus a declaration on the elimination of violence against women. The declaration reflects some provisions found in CEDAW General Recommendation 19, but provides a more thorough and explicit statement on violence. But the declaration does not give rise to legally binding obligations. It's a declaration. It's a soft law instrument. In addition, the General Assembly, the Human Rights Council, and the Security Council have adopted numerous non-binding resolutions, specifically dealing with violence against women. These resolutions have increasingly identified inequality, discrimination, and gender-based violence as violations of human rights of women, and have referred to the heightened risk of gender-based violence for women who suffer multiple and intersecting forms of discrimination. Despite all these developments, violence against women remains a pervasive, widespread, and unacceptable reality throughout the world, with the World Health Organization arguing that it is a global public health problem of epidemic proportions requiring urgent actions. If this was a medical emergency, a medical epidemic, we declare a state of emergency globally. At the regional level, the Inter-American Convention on the Prevention, Punishment, and Eradication of Violence Against Women, the Convention of Belém do Pará in 1994, is the first legally binding instrument in which state parties agree to a series of concrete measures and programs to address this human rights violation. The protocol to the African Charter on Human and People's Rights, the Maputo Protocol, adopted in 2003, aims to protect women's rights in a comprehensive manner. Although it's not exclusively dedicated to violence against women, the protocol includes definitions as well as crucial provisions, including on female genital mutilation, rape, and provisions on the abuse of women in the advertising and pornography. The Council of Europe Convention on Preventing and Combating Violence Against Women and Domestic Violence, which entered into force in 2014, provides a comprehensive regional legal framework to protect women against all forms of violence and to prevent, prosecute, and eliminate violence and domestic violence. The Inter-American Convention is the only violence against women human rights treaty which includes an individual complaints mechanism. The other two regional treaties do not. The consequence of the absence of formal regional human rights systems in the rest of the world reflects the lack of a normative framework for these regions. Under international human rights policy developments, it is argued that states are obliged to prevent and to respond to all acts of violence against women. In my reports to the United Nations, I've argued that there is a need to create a framework for discussing the responsibility of states to act with due diligence through separating the due diligence standard into two categories. Individual due diligence, which states owe to individual victims of violence, and systemic due diligence, which requires states to create a functioning and responsive system to eliminate violence against women. The obligation to act with due diligence also requires states to hold accountable not only those who perpetrate violations of human rights of women, but also those who fail to protect against and prevent harm from occurring. There continues to be a lack of response to addressing individual, communal, structural, and institutional factors that are a cause and a consequence of violence. Thus, we need state responsibility to include both individual and systemic due diligence obligations. Moving from soft law to standard setting to legally binding obligations, there is a growing concern that women and girls who are victims of violence are inadequately protected and served by the current human rights law and practice. There is a gap between the human rights standards set out in soft law policy documents at the international level and the adoption of such standards by national governments. For example, more than 600 million women live in countries where domestic violence is not a crime. As mentioned, currently an important conversation is taking place about how to achieve a more effective international response. My final reports to the Human Rights Council and the General Assembly late in 2015 reiterate my view of the normative gap I saw a sign for 3 minutes, and the need for a new international convention. During my tenure as a Special Rapporteur, I initiated a process of consultations and dialogues, including the normative gap in international law in respect of violence. The submissions included individual information on research and advocacy efforts of civil society organizations. Proponents of a new treaty stress that a legal framework that relies on creative interpretations of general human rights law is inadequate to address the nuance and specificity required to combat violence against women. CEDAW is inadequate as it lacks legally binding provisions on violence against women, including explicit definitions and articulations of state responsibility. Proponents argue that conflating violence against women and discrimination against women results in an inadequate or incomplete description of the legal concept of violence against women as a human rights violation in and of itself. They also argue that addressing impunity is a crucial step to ending violence against women, and a new treaty could give activists and advocates a tool that they need for accountability as well as for state actors to adopt and implement laws. In addition, there is an argument that there is insufficient dialogue within the mandate of other treaty mechanisms, specifically on violence against women. The current UN Special Rapporteur on Violence Against Women has recognized the need to address the gap between international human rights norms and standards and their implementation at the national level. And she has received responses, and particularly from civil society organizations. A majority of civil society organizations argued for the adoption of a new treaty, which would be specifically on violence against women. It would be comprehensive and legally binding and reflect uniformity, specificity, and state accountability, which we don't have at the moment. Some respondents did express concern about the soft law and the non-binding nature of the current legal framework and the need for a new separate treaty with its own monitoring body or an optional protocol to CEDAW. These people who support a new treaty argue that there is an urgent need to establish the uniformity, specificity, and state accountability through a binding legal global instrument, rather than maintaining the status quo with 3 regional systems having treaties and the rest of the world not having any. The current Special Rapporteur has recognized that there is a gap and that a significant number of submissions pointed out that the lack of a specific global treaty on gender-based violence had important symbolic value and further indicated that a new treaty could have an important role in galvanizing implementation at the state level. In 1996, the first Special Rapporteur on Violence Against Women argued that the international community should consider the possibility of adopting an international convention on the elimination of violence against women. There does not exist a comprehensive international legally binding instrument on violence against women. And in 2015, I argued the same perspective, that there is a normative gap and we need to do something. Thank you very much for your attention.